Welcome to this third debate in the law strand at the 2014 Battle of Ideas. My name's Luke Gittos. I'm a solicitor practicing criminal law, and I'm the legal editor for Spiked Online and the convener of the London Legal Salon, who are sponsoring or assisting with this strand of debates here today. We've already had two great legal discussions this morning, so I'm not going to say an awful lot in introduction, but the title of this talk is Victims' Law, Therapeutic Justice, or Moral Crusade. The inspiration for this was really myself taking notice of most announcements around the criminal justice system and reform to the criminal justice system, at least in part paying heed to the need to bring victims closer to the centre of criminal proceedings. And I've flipped and flopped on my view on these reforms, between thinking they're either terrible and disastrous for defendants' rights, or actually just a complete sham and a bit of a mirage, and don't really mean very much at all. I'm interested to see what my panel's going to think. We've got a very highly qualified panel to talk about this topic, so I'm not going to say anything more in introduction. First, on my immediate left, is Sam Cohen. Sam is a criminal barrister at 9 Bedford Row, regularly instructed for the defence and prosecution in relation to a wide range of criminal offending, but also it's fair to say that she has a degree of specialism in allegations involving sex crime. And really it was, she did a talk about a month ago when we decided to do this debate called, she'll correct me on the finer points of the title, but Sexual Prosecutions Post-Savile. And I thought that was an absolutely intriguing title because it was a talk focused very much on the changes in the law that have happened post-Savile and really gave a fantastic introduction to the kind of, well, very thorough going through the legal reform which has been effected in this area in recent years. So I was very grateful to attend the talk, and I'm extremely grateful that she can be with us here today. Second to speak will be Barbara Hewson. Barbara is a public law barrister at 1 Mitre Court Chambers. She writes regularly for Spiked Online and has been extremely outspoken in broadcast media, on radio and television. So we're very grateful for Barbara for being here too. Third to speak to my immediate right will be Sally Fudge, who is a barrister at Furnival Chambers, again specialist in prosecution. The majority of her work is prosecuting work, so it'd be very helpful to have an insight from that side of the profession. And I'm intrigued to hear whether or not the kind of reforms or the kind of effects that I'm thinking have taken place post-Savile actually have played out in the courtroom in that way. So I'm very grateful for Sally for being here and very interested to hear her perspective. And then last to speak will be John Fitzpatrick. John is Professor of Law at Kent University. He's the director of the Kent Law Clinic, which offers pro bono advice to people who can't afford to access legal services or who otherwise wouldn't have access to those services. John has written extensively on this topic, but also more broadly around public law and human rights. He's a very widely published author, and he's a great speaker, and I'm very grateful for him being here today. So thank you, John. So that's our panel. I'm not going to say anything else. I'm going to invite Sam to open up the discussion.
For the bulk of my 20-year practice, I've specialised in cases which have involved people who would be regarded as vulnerable. I'm on the list of advocates who are instructed to prosecute cases of rape and serious sexual offences, and I also, of course, defend in similar cases. So I suppose I've acquired over the years a fairly substantial experience of the way in which the criminal justice system treats people, whether they be vulnerable or robust, whether they be confident or terrified, whether they be witnesses, victims, or defendants. And I start from the premise that every defendant is innocent until the prosecution have proved otherwise. Convictions should only result where there is evidence of sufficient strength to compel a finding of guilt. Convictions on weak evidence bring the criminal justice system into disrepute, and they wreck lives. Our system is adversarial and combative. It's very difficult to find a place for compromise or nuance. And each player in the system has a very different role, really. So defence advocates are not there to find the truth or help find the truth. Their role is to challenge the sufficiency of the prosecution case. Prosecution advocates are not there to prop up a weak case or obtain a conviction at any cost. They are there to ensure that all relevant and admissible evidence is presented to the jury in the most effective manner. Judges are not there to influence the verdict. They are the referee. They ensure fairness, or at least that's what they're supposed to do, and in the event of a conviction, they temper society's outrage at the crime with mercy when passing sentence. But the key to the system with which we are familiar are juries. And juries, in my view, anxiously scrutinise in a cool and dispassionate manner the evidence with which they are presented. And the conviction rates at trial in the cases where most of the victim-friendly measures are deployed, and I'll come on to those measures in a moment, the conviction rates are currently running at about half of the conviction rates in other sorts of serious offences. And that demonstrates to me that although the measures which have been instituted may work to make victims feel better about the process, they do not lead and have not led to substantial increases in conviction rates. And my take on that is that juries are working. They are filtering out weak cases and they are convicting in strong ones, which I think is how it should be. It can be helpful to recognise just how far the system has come, because when I started, quite frankly, the way in which many participants in the criminal justice process were treated was nothing short of a national embarrassment. It was common practice for rape victims, and incidentally, I'm using the word victim not because I take the premise that every allegation is a true allegation. Complainants perhaps would be a more appropriate word to use. But complainants were interviewed by whoever happened to be on duty at the time, and they would be often asked, quite frankly, offensive questions about why they'd done what they'd done, why they'd worn what they'd worn. And if you were a sex worker and you went into a police station to report an allegation of rape, well, you could go whistle, because nobody was taking that seriously. If your victim or a witness was less than robust, if they were intimidated by the prospect of going into a courtroom and confronting somebody who had attacked them, or if they suffered from any kind of learning difficulty, if they were a child and they didn't always grasp with accuracy or alacrity the questions that they were being asked, then they were abandoned to the system. And so many of the reforms that we have seen have corrected those obvious deficits. So screening of witnesses, the use of specialist police officers and lawyers, and the use of intermediaries are, in particular, very useful reforms. There are others, which I will, I hope, be able to deal with in discussion, which, in my view, either don't work at all or, in some cases, are gravely detrimental to the fairness of the trial process.
Great. Thank you very much, Sam. Barbara.
When Sir Keir Starmer, former Director of Public Prosecutions, announced that he was going to campaign around the idea of a victim's law, I thought this sounded a very vague concept. And I tend to agree with Luke's suggestion that really all this talk about a victim's law that we have from both the political parties at the moment, both Labour and the Ministry of Justice, is really a form of PR. It's a kind of political point scoring. If you say victims' rights, it sounds like motherhood and apple pie. Who would disagree with the idea that victims should have rights? But in fact, we know that the English legal system has given victims very substantial rights for a very long time. You have the right to compensation from a state criminal injuries body. You've always had the right to sue the wrongdoer in civil courts if he's got any money. Victims of sex offences or of blackmail and certain other types of crime can claim anonymity. The special measures which are in force, which have been referred to, such as the opportunity to give evidence behind a screen or by video link for those witnesses who are deemed vulnerable, were in place before the Human Rights Act came into force. And judges and advocates are regularly trained on the best way to approach the questioning of vulnerable witnesses. Witnesses who successfully testify that they've been the victim of a crime also have the right to give a personal impact statement to the judge at the sentencing stage to tell the court how the crime has impacted on them. And the CPS also gives complainants a right of review. So if they decide they're not going to take a complaint forward, the complainant has the right to have that decision looked at again by somebody else. And if they decide not to prosecute or to discontinue a prosecution, the CPS must meet the complainant to explain the reasons. Victims, as matters stand at the moment, are very much at the centre of the criminal justice system, and I think we should interrogate very critically suggestions that they are in some sense on the periphery and that they are in some sense being disadvantaged. In fact, if you read the newspapers, you would think that victims are a new form of oppressed minority who need liberating from the cruel shackles of our criminal justice system and its heartless gangmasters, the judges and the lawyers. And that I suggest that this is a complete parody of what is in fact going on. I want to discuss the use of the term victim because in all official policy documents now, both domestic and also coming from the European Union, which has a big section in its crime and criminal justice programme on victims' rights, you will see the word victim being used to mean both the person who reports a crime to the police and someone who has successfully testified against an accused in court. And this elision of complainants and victims, I think, is very problematic. Both the CPS and the police now routinely speak of victims and the need to support victims in their public pronouncements. And it seems to me that what they're trying to do, not very subtly, is to condition the public to accept a presumption of guilt. And I think this is dangerous. So I think we should look through the rhetoric and consider what's going on here. The UK criminal justice system has for many centuries operated on a presumption of innocence. And what some of us who've been concerned by recent trends, particularly post-Savile, are concerned about is the feel that this presumption of innocence is being subtly reversed in certain types of cases, particularly allegations of historic sex crime. Keir Starmer has been highly influential on this idea that we must believe the victim. He introduced new guidelines on the approach to be taken in assessing witness credibility in child abuse cases last year. And according to him, it is, quotes, more sophisticated, unquotes, to start with the presumption that the victim is telling the truth. Now, it seems to me that for prosecutors and police officers to start with that presumption is deeply problematic, because effectively what they are turning themselves into is a kind of advocate for complainants. And it isn't the role of the state prosecution system to act as an advocate for complainants. In fact, the CPS policy document says we do not act for victims of crime or for their families. We have to act in the wider public interest. It seems to me that the approach that Starmer has advocated, and which has been taken up very enthusiastically, in fact embeds an ethos of child protection work as it's evolved over the last 3 decades or so into the criminal justice system. And this idea that we must believe the complainant has in fact resulted in a certain dismantling of safeguards for accused people, to a point now where some of us are really quite seriously concerned about whether or not defendants, particularly in these very emotive cases involving allegations of child abuse or sex abuse, can receive a fair trial. For example, the need for warnings about corroboration have been abolished. The media pretty well have free rein to make very prejudicial comments pre-trial. The rule on similar fact evidence, which prevented multiple complaints against a single accused by different people, has been dismantled. And there is a real concern that the rights of the defence have already been quite seriously eroded, and this is not something to be proud of in a mature democracy. Indeed, one professor of criminal law says we no longer have a due process system of criminal justice in this country. We have a system of crime control. So I think this is worrying, and I'm glad we're here today to debate all of this.
Great. Thank you, Barbara. Coming in just under time. Thanks.
I always remember in the early years of my practice being told by a judge that a person was not a victim unless and until a defendant was convicted. Until then, the person was a complainant. Whether that is right or wrong, and I must admit I had changed my use of the word since. Obviously, debates such as this and the recent changes in law and the political suggestion show that perhaps there are still issues to be considered, concerns raised by those who seek their justice through the courts. I've recently been appointed to prosecute cases involving rape and serious sexual offences. Of course, those are the type of cases where one's most likely to see the most vulnerable individuals coming before the courts. There are already a number of safeguards in place to help them through the process. But it seems that the view is that there's still not enough. One question I have is whether such measures should be extended to complainants or witnesses of non-sexual cases. They too can still be vulnerable, have needs that are not being addressed. Of course, this is all complicated by the fact that all cases are different, all witnesses are different. There's not going to be a one-size-fits-all solution to help every individual that does come through the courts. Perhaps one needs to look at what problems or perceived problems there are to start with. Of course, there are different stages to the trial process and different needs arising. First of all, you've got what I would say pre-charge. Before somebody has even been charged with an offence, the police have to obtain evidence from the complainants, from other witnesses. At the moment, those who are considered vulnerable are interviewed by way of video recorded interview, just the officer and the witness in a room together, go through the account and questions asked so that everyone can then see the person's demeanour in a much more informal setting than the sort of clinical courtroom. For serious sexual offences, the complainant is assigned what we call a SOIT, Sexual Offences Investigation Team officer, someone who is trained to deal with such cases. They have that person assigned to them to guide them through, to answer questions, to be there for them. You then have pre-trial, after a person has been charged, leading up to the trial, preparing a complainant or a witness to give evidence. I'm not for one moment suggesting we should resort to the US style of coaching a witness before we get to court, taking them through their evidence and challenging them. That, to my mind, undermines the whole integrity of the trial process. But perhaps more assistance in letting them know what they're going to be faced with, who's going to be asking them questions. There are pre-trial court visits, but perhaps more interaction with a prosecutor beforehand. There is a pilot scheme running at the moment about pre-recorded cross-examination in some cases, where ordinarily a defence advocate would be allowed to cross-examine in front of the jury in the courtroom. The pilot is now allowing for that cross-examination to be video recorded in the same way that the initial account is recorded, again taking the complainant out of the sterile courtroom. During the trial, and this perhaps seems to be the focus of many of the concerns, methods of cross-examination, if it is to be done in court. There's been a suggestion that defence counsel should somehow be trained before they are allowed to undertake these kind of cases. There is a sort of irony to this, because to prosecute rape and serious sexual offences, you have to undergo CPS accredited training first, that there's no such thing for defence. And of course, it's the defence advocate that has the unenviable task of cross-examining the complainant, perhaps the trickiest part of the whole trial process. But I can't say that I'm particularly in favour of asking every defence counsel to go through training beforehand. There's an Advocates Gateway website that has a number of toolkits on it, sort of a checklist of what should and shouldn't be done when preparing to cross-examine and the manner in which cross-examination should be carried out. And of course you have the judge, who has an incredibly important role in ensuring that whatever questions are asked are fair, they are short so they can be easily understood, and so that the case can be put properly. And of course then there's the post-trial, after the complainant's given their evidence. We have victim statements. Perhaps more need to keep them updated as to the outcome, what's actually happened. A lot of what I've suggested is already being done. And as a prosecutor, I find myself perhaps a little surprised that I do lean towards what Barbara was referring to. The bottom line has to be a defendant is innocent until proven guilty. And if we extend the victim's rights too far, then we are perhaps in danger of undermining that and putting the defendant second. I will stop there as I've had my red card.
All right, thank you. John?
I'm afraid you're going to hear more concerns expressed about the move to put the victim at the centre of the criminal justice system. I think it was intended that there be somebody here who might put more of the other point of view. Unfortunately, that's not been possible. But having said that, there is a lot to discuss, and perhaps, and I hope people here may stand up for the move that's recently been proposed. The victims' law that has been proposed by the Labour Party, you might appropriately judge that by considering that only a few weeks or a couple of months after Labour proposed it, Mr. Grayling said, no, we're going to bring in a victims' law, which will give you the sort of, I think, the measure of it. So Grayling's going to bring in a victims' law, and then Labour's going to bring in a different victims' law if they come in, if they get elected. But let's talk about victims, and talk about victims subject to the interrogation that my colleagues on the panel have already given the term itself. But there are victims. And what is it that victims want from the criminal justice system? What is it that they want? They want to be dealt with compassionately. They want to be listened to. They want to be kept informed about the process of the investigation. They want to be dealt with considerately in the manner of their being brought to court. They don't want to be abused, humiliated, criticised when they give evidence in court. They want to be heard in their own voices about the offence that's on trial. They want the perpetrator to be convicted. And they want the perpetrator, the convicted person, to be punished appropriately. They want justice. Is that too much for a victim to ask from the criminal justice system? Well, yes, it probably is. It probably is when you break it down. Not in respect of a lot of maybe those preliminary issues and important ones. And again, it's important and it's good that those things have been addressed, that they've been treated more considerately, that they've been kept informed, that they're treated with a certain amount of respect and so on. But it's not possible to say that the victim's account of justice is justice at all, in the sense that we should accept it. That's the problem. It's a starting. It's a simple problem. It's a profound and intractable problem. English law started in its recorded form from taking the victim out of the centre of the criminal justice system. The criminal justice system at that time was called the blood feud. And the victim was entitled to satisfy himself by taking action against the perpetrator, or by the victim's kin doing that. The justice of the victim was a justice of revenge, of vengeance, of vendetta, of the kinship feud. And the laws of Ethelbert of Kent, or the Kentish people, the Cantuara, in 604 AD, that were said to lay down the tariffs that were to replace, vengeance and revenge being taken by the victim, to replace the victim being satisfied, with the polity generally being content about that this was the best way to proceed. And that, of course, is one of the most important aspects, civilizing aspects of the law and of any criminal justice system worthy of the name. And it's got to take all facets into account. I think it was put most pithily by a colleague in the Manifesto Club, Josie Appleton, once. Justice is done not when the victim is satisfied, not when the defendant is satisfied, not when the opposing lawyers are satisfied, not when the judge is satisfied. Justice is done when society is satisfied. Justice is done when we see that it is right to punish, it is right to inflict retribution, it is right to deter, to prevent, to rehabilitate. But it is also right to restrain, and to do this in a civilized manner, in a clinical and restrained and calculated manner, uninfluenced unduly by emotion. And that was that's the starting point in all of this. To put the victim at the centre in the way that is rhetorically said, it is rhetorical, and in many ways it is rhetorical rubbish in the sense that it isn't intended that much of an immediate impact. But it will have an impact, and my word, it has had an impact. It's had an impact on the criminal justice system itself in the sense that the pressure that it brings to bear on the whole process, not just at the sentencing stage, but at the whole process of the trial, has already been felt. My colleagues have referred to many changes in the law that have been made. You can add, and we can talk about many others as we go along. Those changes have been made to the law, and they have made it easier to convict people. And that flies in the face of the obvious observation that to make it easier to convict the people the police arrest and put on trial, to make it easier to convict those people, of course it is fallacious to suggest that that will protect people or even satisfy victims in any superior way. It won't. It will simply make it easier to convict people. And those laws have changed, and I think it is easier to convict people. I've got to pause there.
So the way this works is I ask a couple of questions, quick questions, which the panel then briefly respond to, and then we come out to the audience as quickly as we can. I think, to start, I think there's some clear dividing lines, even though I think there are two perspectives being drawn out here. On the one hand, we have, I think, Sam and Sally arguing that really these reforms are practical and are limited in ensuring that victims have a reasonable experience of the courtroom and they're not unduly stressed or emotionally harmed by the process of going through the courts, and that really these reforms have no impact really beyond the practical interaction between complainants and the courtroom, whereas the speakers on the end of the table seem to be suggesting that this is part and parcel of something broader, which is actually having the effect of undermining justice. I wonder whether you see this as part of any broader trend. Do you accept the idea that prosecution policy or any other approach or any other aspect of our criminal justice system has been affected by this victim-centred outlook? Do you even accept that there is a victim-centred outlook to the criminal justice system today, or is it simply that we're making these practical arrangements to ensure that victims have a reasonable experience of the courtroom? And to Barbara and John, I think one startling fact and a piece of material that came out in the first two discussions really is that it hasn't had the kind of impact that you might expect. It hasn't led to a significant increase in convictions. And there's no significant difference between the level of convictions in cases where these measures have been employed and those cases where they have not. It seems to me that's a pretty hard piece of empirical evidence that you need to deal with if you're going to suggest that this is going to lead to the undermining of justice and a huge flurry of new convictions. So they're just some ideas. I'll take reverse speakers. So that's not very clear. I'll go in the reverse order when we're responding to questions. So John, do you want to start with that?
Well, I think that the 2 points that I'll pick on that you've raised, it hasn't increased the proportion of people who are being convicted. I mean, these are these figures are very, very dangerous indeed. I mean, to deal with and to assess. There's been a very considerable rise, for example, in the reporting of sexual offences, and we've seen again this year. There's a massive rise just over the last year on the reporting of rapes. And so the figures have to deal with reporting, and then they have to deal with the percentage of those that are successful in court. It's very difficult to track. It's very difficult to track indeed I don't think or to track any reliable lesson about has this impact resulted in that way. My point about it was that if you allow the bad character evidence, similar fact evidence of the defendant, if you restrain the bad behaviour questioning of the complainant, if you provide anonymity, if you redefine the offence, which rape has been redefined, then if you abolish the corroboration, the mandatory requirement for corroboratory evidence, if you go to take all those measures, every single one of them adjusts the rules of the criminal justice system in favour of the prosecution. And common sense says that however the figures play out with respect to how many were reported and how many were convicted, common sense suggests that we should be careful about that. But the second point on the victim, I mean, this is terribly important. I don't know whether people do dispute it, but let me put it out if they do. I do think it's a much broader issue, because what the statement, the rhetorical statement I said impacted on the criminal justice system, it also impacts on society at large. It is promoting the idea of vulnerability. It is promoting the idea of victimhood. It is promoting the idea that people, for example, they can't move on. That they must have satisfaction within the system, rather than, as has been the case, that people were encouraged to move on with finality, not necessarily with getting either the conviction or the sentence that they wanted. But, them not being encouraged to think that their lives were now forever damaged and spoiled. It seems to be, nobody ever seems to suggest to somebody to say, well, don't dwell on it. You're not necessarily scarred for life. You don't have to write a victim personal statement. I'm not against victim personal statements themselves. And I don't think they're as bad in this jurisdiction as, for example, they are in the United States, post-Payne and Tennessee, the case there. But this pressure on people to dwell upon, to consider, to emote about, to express, what's happened to them, rather than get on with a process that they can be satisfied with, that the system is bringing somebody to court, it is trying to see if they did it beyond reasonable doubt, and it's trying to punish them appropriately according to what everybody thinks, and just doing that. And not just in the criminal justice system is this idea of dwelling on the past, or dwelling on what's happened, dwelling on mishaps, is it being promoted? I mean, I think recently, I watch it, the Hillsborough inquiry, and you see this endless going over what happened. To find out what happened. The dogs in the street of Sheffield know what happened at Hillsborough. Bloody Sunday, how long did that take? To take. Who didn't know what happened at Bloody Sunday? But it had to go. And so what you get is not just the promotion of, well, you must have really suffered. We want you to really dwell on that and to think about it again and to go through a whole process about it again and don't leave it behind, cling to it. And what's more, appeal to authority to validate your pain. Appeal to authority to resolve this issue, because you can't do it. You've got to go to a judge to do it. You've got to go to a committee of inquiry to do it. Then you'll feel better. No, you won't. You'll be even more dependent. And that's the problem about the wider process as regards society.
Great, thanks, Jonathan. That's very clear. Sally?
Question that you raised about the sort of practical impact within the court, within the trial setting. One example that immediately springs to my mind is the use of what we call special measures, different ways in which witnesses can give their evidence to the court to put them more at ease, to give them the chance of giving best evidence. You can give evidence from behind a screen, you can be seen through a television link where the person is physically in another room in the court building or indeed somewhere else, and we can just see them on a screen. And I've mentioned the pre-recorded cross-examination. There's another one for those that have particular needs, the use of an intermediary, a professional person who can assist the person giving evidence if they don't seem to be following the questions asked, if they need particular assistance. Now, of course, all of those are available for prosecution witnesses, but they're not available on the same level to a defendant. And that, to my mind, seems to be unfair and unnecessarily unfair. Why should a witness, a prosecution witness, be allowed those protections to make them feel more at ease in giving evidence to a jury and before a judge, being questioned by the barristers, when a defendant can't have those benefits? All right, screens is to put distance between the witness and the defendant, but so far as taking a defendant out of the clinical aspect of the courtroom or having the assistance of an intermediary, I don't know whether it's still the same now, but certainly there were an enormous amount of funding issues for a defendant to have a benefit of an intermediary. I think that has now,
That's now been resolved, yeah.
resolved, but even that took a lot of time. Why should it take so long for the defendant to have those protections in the same way as a witness? When a judge sums a case up to the jury, he says to them, you must treat every witness in the same way. They come before you from the same starting point. The defendant is no different because he comes from the dock. Well, is that actually right when we are treating them in a different way at the point that they are giving their evidence? So I think whilst there is clearly a move towards helping witnesses to give their evidence better, perhaps there needs to be an evening out to help those defendants who may feel it difficult in giving evidence as well.
Great, thanks. Barbara?
One of the things we haven't really talked about is the power of what I would call loosely the victim lobby, and that's obviously made up of a number of interest groups, some of whom are very activist in their critique of the criminal justice system. And what you often see them doing is complaining whatever the outcome is. So if there's a conviction, they'll complain about the way the witnesses were treated during the trial, and if there's an acquittal, they portray this as a disaster, and say that the poor complainant who's given evidence is going to feel terrible and she's not going to feel believed, and so on. And I think that they very much deploy the therapeutic rhetoric that has crept into this whole arena, and they use this idea of trauma. It's very common to see observations like, what about the victim? She's had a life sentence, you know. This was in the context of a discussion that erupted earlier this week about the TV presenter Judy Finnegan commenting on the release of Ched Evans. These groups now have acquired a certain traction within government, so that whenever they kick off about some aspect of a trial that they are not happy about, you get this kind of knee-jerk reaction on the part of a minister who says, oh, well, you know, something will be done. And I think that it really goes against a kind of informed discussion about, you know, where are the pressure points within the system. I'm actually fully in agreement with you about the way defendants are treated. I think we should abolish this whole idea of defendants being in the dock. If you've been following the Oscar Pistorius trial, he just sits behind his lawyers in the same way as they do in the United States. And that gives an impression of a level playing field, which is quite subtle but also quite important. I think I am concerned about this kind of retreat from the courtroom and this sense that more and more people giving their evidence ought to do so away from court or not even during the trial, because I think that suggests a loss of confidence in the trial process, which I think is quite troubling. And I don't think that enough people are debating this and contesting it, because, as has been explained, it's perfectly reasonable for people to be able to give their evidence in a civilised atmosphere where the judge is keeping charge of the trial and is making sure that counsel don't abuse their position by asking inappropriate questions. And I think it's wrong in principle that people should be encouraged to think of themselves as vulnerable. I mean, clearly with very young children it's a different story, because with developmental issues and so on, the way in which they understand questions and their reaction to being in court is going to be very different from that of an adult. But it does seem to me we've gone a bit the other way. For example, I noticed in one of the historic allegation cases that was on recently, the two women who were both in mature middle age were referred to as Girl A and Girl B. And there is something about, after 40, 50 years of feminism, women are still being referred to as girls, and is there not something somewhat infantilizing about that, that we should be challenging a bit more?
A lot's come up, so feel free to comment.
First of all, it does seem to me that this focus on talking about how people feel about the process that they're going through, which seems to be at the heart of victims' rights, can be a disguise for more fundamental problems, or funding problems in particular, within the system, because one of the major complaints that victims and witnesses have of the system is the delay, which is extraordinary. And it can be, of course, delay also massively affects defendants. You can have people who are on bail to a police station for really ludicrous amounts of time, up to, and indeed sometimes over a year. And it's not just sex cases. Fraud cases are absolutely appalling, because there's often a huge volume of material that needs to be examined by the investigator, and while that is being done, the person waiting to be charged with something that could lead to a prison sentence of some years has their entire life in limbo. And of course, then there's delay getting cases on to trial, and then there is also the delay that happens very frequently at court. I mean, I was doing a trial week before last, and I realised, as I was waiting yet again for another hour for the court to be free, that I don't think I've ever actually had a trial that has started on time in a criminal court, ever, which is pretty remarkable. The reason for this is money. If you don't have enough policemen, and you don't have enough investigators, if you don't have enough analysts to go through all the computers that you seize from people when you arrest them. Just think about conspiracy to supply a Class A drug. You arrest a group of 6 or 7 young people. Each one of them has a computer, an iPad, a couple of phones, an old phone that's in their bedroom drawer, and a couple of SIM cards. And there are 5 or 6 defendants. So you seize all that material. You're looking, before you even start, you've got upwards of 30 or 40 devices. Each one contains a huge amount of information. But what you need are large numbers of people who can download that material, analyse it, and see whether there's any evidential benefit in it. But instead, that takes 9 months to do, because we don't have enough money within the system to pay people to do the job with any kind of sensible speed. And I suspect that if Chris Grayling were to say that he'd like to increase funding into the prosecution of offences by £1 billion next year, probably much of the delay that's built into the system would disappear, and I suspect that victims' experiences of the system would be hugely improved. And it's a shame if that practical solution is being disguised by other ways, other statutory ways of improving people's feeling about the system. That's one topic I can...
Great, thank you, Sam. Okay, so I'm going to come back to the audience.
I'd like to talk about murder trials and say that personally I cringe when I hear the bereaved relatives talking about their pain, because I always think, what about the homeless person who is murdered? What about the child who is killed by their own parents, and somehow they are almost sidelined by this concentration on the victims.
The right to review that was mentioned, is that, I mean, you mentioned it's done by other people, is that done by some other part of the CPS, or is that completely independent of the CPS? And what do you think of its efficacy, and how used it is?
Well, that's an interesting question, because obviously the right to review, for those who don't know, was a new mechanism whereby those who have been told, or victims, complainants who have been told that their case hasn't got enough evidence, can then now challenge that decision, and thus adding to the kind of delay for defendants that Sam was talking about. So that was one change, which actually really did have an effect on defendants, because it means they have to wait longer to find out whether or not their case is going to go anywhere.
Everything we know from scientific research and memory strongly suggests we should not be even looking at cases that are decades old. The idea of cross-corroboration, when you've done a police cum media trawl, it's guaranteed to bring forward several people who widely exaggerate past experience, if not completely invent them. Those historical cases, if you look at contemporary rape cases, I mean, there have been surveys done of specialist rape investigators around the world, and the stats that come in, what they think, in their opinion, based on their experience, is that between 50 and 90% of all formal complaints to police are in some way false, whether not necessarily out-and-out fabrications. There's a guy who used to run the Met, so he did one, it came out 57% from the Met. If you look at the Home Office special studies on rape, there's been 2. Police, despite decades of draconian imposition by the Home Office, still record over 10% under no crime. You can't do that unless there's actually a written retraction from the complainant. There's 35% are under no further action. Conservatively, based on those figures, an estimate of 30% of formal complaints to police in the UK are in some way false. So clearly, there is something special about sex offences generally, and we surely have to go in the opposite direction to where we've been travelling.
I think it's a really important point that the role of the victim is to strengthen the power of state authority and the prosecution, which is a new kind of form. I think that previously, when you've had very strong state authority, it's occurred through treason trials, star chambers, inquisitional courts, essentially courts where state authority overtly took the role of we are defending our interests. And as we know, the rights of defence in this country developed in response to very aggressive treason trials carried out by the state, where the state was the victim. It's a different form to those previous forms. In a way, the state is speaking through the voice of the victim. And in some ways, it seems that the victim is the only citizen to which the state can relate now. And also, the only way in which it can justify coercive authority is through taking the part of this voiceless, otherless, kind of figure. This is very clear also in the Antisocial Behaviour Act that's coming through on Monday, which is all about putting the rights of victims at the centre of things. And there's a right to a community trigger, which is basically like if you make a complaint or 2 complaints, then you have a right to have your case taken on. This is actually giving the greatest degree of summary power to state authorities that has ever occurred in any European country. So you see actually very clearly how the rights of the victim is really the arbitrary power of one council officer to sit there and say, I'm going to ban this or that in this square. But it's a different form to those old forms of the Star Chamber and the treason trial, which are very much more overt, the state defending its interests, but nonetheless coercive for that.
The English justice system is based on the assumption that you are innocent until proven guilty beyond any reasonable doubt. And what these new powers do is they seem to turn it more into a tool for the victim to get some kind of vengeance or some kind of commiseration, and so they feel satisfied after what has wronged them, what they think has wronged them, has happened. So it seems less of a fair trial and more of an attempt to try and mean that the prosecuted person is found guilty. And the more power you give the victim, the more it becomes a tool, more than a fair way of finding out what happened.
Is our model of a human being now one that's psychologically damaged and vulnerable? And I ask that question because to what extent do we think the remedy to this problem can be found within the legal sphere? Or is the legal sphere simply a microcosm of the broader cultural trends that you're finding across society, how we view people? And somebody brought up the Chet Evans thing, and I'm very interested about the implications of how, when you describe someone as vulnerable and potentially psychologically damaged, they then get invoked to say a guy who served his time is no longer able to perhaps take up a role like a professional footballer. And final little example, I don't know how many people are aware of the case study in Northern Ireland where the IRA shot dead a judge. They shot him dead, and that was that. There was a conflict. The Troubles finished. There was a peace process. And in the Stormont Assembly, Sinn Féin appointed one of their SPADs, Special Political Advisor, a woman called Mary McCardle. And what happened? The judge's daughter, Mary Travers, decided to campaign against the appointment because she said she was feeling damaged. She effectively, under the guise of being damaged and vulnerable, created a situation where you now have a new law in the Northern Ireland Assembly where if someone has committed a crime, they're not allowed to hold a post, a job in that assembly. And I think that's a concrete example of the fact that we're not exaggerating the dangers of when you elevate the victim culture to where it is now.
Okay, interesting expansion of what we're talking about.
What I find especially concerning about this move towards the sort of sympathy, like this very public sympathy towards the victim, isn't the fact that it seems to come from a really well thought out argument happening in an environment like this, but that it is massively scandalised people in massively outrageous and sensationalist stories that hit the news. And every time there's a knee-jerk reaction from Chris Grayling or whoever his equivalent person is at the time, say, we'll crack down on this by doing X, Y, Z to do this. And I think, given that the victims hold such a fantastically strong political stake and public stake, like they're very appealing to write about, it means that public opinion is always going to be skewed in their favour unless we have a radically different press, which we're not going to have anytime soon. I think we almost have to use the justice system to really hold back against that political and sensationalist approach, because otherwise you end up with, like the lady said before, you end up with a white girl who goes missing, ending up with a lot more sympathy and effort poured into her than a young black boy from South London who doesn't get the same kind of attention, or the processes, there's less interest in that person getting justice, or that homeless person who's being killed getting justice. I think the publicity in these cases can be potentially really damaging.
Certainly my experience of the trial process is that whatever is happening outside of the courtroom in the wider public debate, which of course must have an influence on juries because they are members of the public, but once you get into a trial, it becomes a very insular process. And certainly verdicts would tend to suggest that juries really do what they're supposed to do, which is to scrutinise evidence and not to be affected by the wider public discourse. And I think that's the reason why there is, and certainly my experience is borne out by the statistics, although I do entirely agree that it's very, very difficult to tell from statistics what the true position is, but certainly there is a far higher acquittal rate in sex cases that go to trial than there are in all other sorts of serious cases. And my feeling about that is because very commonly sex cases will involve an allegation where it's one person's word against another with no supporting evidence. Juries are well aware of the huge penalties for conviction, and juries acquit. Unless there is a very strong allegation, juries do in fact acquit. And so my concern is that what I don't want to see happen is an eroding of the position, the central position of juries in trials, because they are a decent arbiter of public opinion, in my view, as to the strength of evidence.
Just picking up on it, do you think there's a danger that if this becomes a focus of the justice system, if we accept that the reforms are part of a broad trend, maybe, do you think there is a danger that the position of even something as sacred as the jury might be undermined?
Well, it is potentially undermined. I mean, every now and then some politician pops their head up and says, oh, you need specialist tribunals in sex cases because normal people don't understand what's difficult, the difficulties. Or fraud cases are really complicated, and so you need specialist panels of assessors. They're not complicated. They're about human dishonesty. And human beings understand dishonesty. And you don't need professional assessors of dishonesty to decide whether somebody sitting in an office did a really wicked thing when they were changing what was on their accounts. but I do think there is a danger that we will see calls to erode that.
I'm only jumping in because we've got a discussion coming up next on the juries and the place of the juries. So I'm holding thoughts for that, if at all possible. Barbara.
I wanted to say something about the Human Rights Act. That's being used by a lot of critics of the current system, notably Sir Keir Starmer, who's published quite widely his thoughts on this since he retired as DPP. And what's evolved through the introduction of the Human Rights Act in this country is this idea that, aside from the state having a negative obligation not to interfere with your freedoms, the state also has a positive obligation to achieve certain results. It must provide you with effective criminal sanctions. It must provide you with effective investigations of reports of crime. And so this idea of the state's positive obligation is one of the drivers which is being used by campaigners who say that the present system isn't getting the results that we ought to, bearing in mind the number of complaints that are being made, say, in the field of sex crime. And we now have had a decision from the High Court which has equated a police failure to investigate a complaint of rape with torture under Article 3 of the Convention, which I have to say I think is a very peculiar decision. But you can see the pressure this puts public bodies under if they're constantly being told that every time a complaint of rape is made, they're expected to, as it were, produce a result. And so it seems to me that they're casting around for ways in which they can meet these kinds of complaints, which are being made more and more. And you now find the police are being sued for failing to investigate complaints of rape properly. I imagine it's only a matter of time before the CPS will be sued because a rape accused was acquitted. This will be said to be a failure in the system as well. So you have a sense in which there's a kind of Pandora's box opening up, using the rhetoric of human rights to critique the way our existing system works and to suggest that there's something wrong with it, which I just wanted to throw into the mix.
Thanks, Barbara. Sally?
Something that we've recently been asked to do as prosecuting counsel is to, whenever there's an acquittal, is to report back, fill in a form, and explain how we think an acquittal might have been avoided. All right, there are some obvious times where there may have been a bit of evidence lacking, but bearing in mind we are not entitled to know what goes on in a jury room, and I think that must remain throughout. It's another example of this sort of almost air of desperation of the public think that we aren't getting enough successful rape prosecutions, therefore what can we do about it? Rape is one of those peculiar offences that it is hard to get a conviction, and a lot of the time it does come down to public perceptions, how jurors think a rape complainant is supposed to behave, why didn't they run screaming and crying to the nearest available person, why did they keep it bottled up for periods of time. Going back to sort of the comments towards the end about the courts turning into a tool for the victim rather than fact-finding, I think we have to ensure that the court system and the courtroom keeps its integrity and its independence and is there to find out what the facts were through asking questions and for that jury to make its decision. I think if you allow the politicians, others to start dictating what should and should not go on in a courtroom and effectively trying to take it out of the control of the advocates and the judge, then we're getting into very dangerous territory.
Thank you, Sally. John?
On the rape thing in particular, it is a particularly difficult crime to prosecute and to secure a safe verdict about. And that's the so-called justice gap, because there are a lot of reported offences, and as Sam has said, you know, if you compare convictions in that field with other serious crimes, they're much lower conviction rate. That is true. That doesn't, I return to the other point about we'd really need to compare convictions for rape now, you know, for those that are reported with previous times, to see whether or not more convictions are getting through proportionately. And that's the point. Because it is difficult to know what went on between two people at one time on one night, It is simply difficult to secure a conviction that is safe. It is difficult for juries to be sure, beyond reasonable doubt, that the person is guilty as charged. And that's the point that Sam was making. Juries are doing their job on that. And we won't close the justice gap by making it easier to convict people who are charged. You know, so we'll get somebody, we'll improve the rate, and the justice gap will be closed. No, it won't necessarily at all. You are likely to be catching people who didn't do it in the sense of the guilt that is required in those cases. So, I mean, I think that's an important one. I do agree as well that the Human Rights Act will be used, and the Human Rights of the European Convention will be used to undermine the jury. And everything must be done, you know, to defend the jury, for a whole host of reasons. Leave that to the next session. John Holbrook was making the point very eloquently this morning that one of the real point about the development of human rights law in this country is that it has distanced people from having any purchase on what the law is. It's bad enough it being, you know, with a parliament that's not working and not being responsive in the way that it should be, and then you put the matter over to judges on whom you have even less purchase, and then it goes off to judges in Strasbourg who have less purchase still. But here's a situation where the government says, well, we're listening to the people. The only place we are, they're not, of course, listening to the people. You know, they're not listening to victims. They're, you know, promoting and fomenting victimhood, you know, and then using that, you know, in terms of control, in terms of the dissemination of what you asked at the back about what a human being is. And that's, to get back to that point, and very much if there's a person in front there who said, you know, what is the criminal justice system's about, you know, convicting people beyond that you're sure beyond reasonable doubt have committed a crime. That is what the criminal justice system should be about, and it may be added, and also to acquit those who may be innocent. You know, that is the purpose of the criminal justice system. And it is a very difficult process. Shouldn't need saying. It's a very difficult balance to strike between securing the just, beyond reasonable doubt, you know, conviction of those who are guilty on the one hand, and not letting off, you know, those who may be innocent unduly, unjustly. There's no gain there either. And the result of this difficulty is that there's a very carefully, very detailed, calibrated system of checks and balances, both with respect to the law, the offences themselves, and the procedures that are employed. They're very, very closely monitored, and it's the job of the judge to ensure they're followed. So to make sure that fairness is observed at all stages. The difficulty that we've got is that, you know, I would say since the Police and Criminal Evidence Act of 1984, just about every criminal justice measure has made it easier to convict. There's some exceptions, for example, the requirement to disclose, the prosecution's requirement to disclose evidence, and that was diluted afterwards. On the whole, every single measure, and there have been a host of measures, particularly since about 1993 and after 1997 in particular, and every single one cuts away, makes it slightly easier. The calibration is adjusted. And that does undermine the fundamental principles. And here's the point about those principles. You know, what are they? The presumption of innocence, the right of silence, you know, the beyond reasonable doubt, the burden of proof beyond reasonable doubt, the standard of proof beyond reasonable doubt, the burden of proof on the prosecution. These standards are absolutely crucial, not simply with respect internally to the criminal justice system, they're crucial in expressing who we are. Because those standards say you're entitled to be defended. We're not going into the criminal courtroom with a level playing field. You know, you're going to go in there and you're going to be presumed innocent. The prosecution have to prove something against you. It's not even Stevens. Why not? Well, it may be one thing is they're more powerful than you, an important factor. But even more important than that, you don't go in on an even playing field because you are somebody, because you matter, because you have a certain status, because you have an autonomy that has to be respected and upheld. And so attacks on victims are not just attacks on defendants. Attacks on defendants in the name of victims are not just attacks on those defendants. Those attacks are attacks on everybody. They're attacks on the conception. If the values and standards of the criminal justice system are amended in that way, if the presumption of innocence, as it has been, is undermined and diminished, we are all diminished. And that's what we're trying to defend, that sense of who we are, a sense of we're entitled to that, a sense of our own importance in this matter that was respected. I say was, because it isn't and hasn't been respected as much as it has been in our criminal justice system. If anyone's interested, I think 1966 was the high point. We come back.
Thanks. Thanks. Okay, we've got about 20 minutes.
I found myself agreeing at the beginning with a lot of the comments that the panel made, and but got me thinking when Barbara Houston talked about possibly levelling the playing field, and just following on a little bit from what John Fitzpatrick was saying, by having a sort of American-style Judge Judy thing where the defendant and the complainant sit at the front, rather than having the dock. But it made me think that perhaps what we need is more perhaps a bias towards the defendant. And while I don't want to come across as a hardline nutter as far as how things used to be, I'm certainly not nostalgic, but perhaps the old-fashioned thing of the police not believing you is a way of, at least from the point of view of the complainant, reminding them that this is a very serious thing that they're doing. This is a very serious thing that they're invoking the power of the state to take action against somebody else, and that it might actually make them think about whether or not a crime has been committed, whether or not they are actually in the modern terminology, a victim of crime. And while I don't necessarily want to advocate that we should go back to police taunting people in the police station and not believing them, maybe there is in some way some value to that.
I see what you're getting at, and I think it is an interesting concept whether or not a victim has ownership over what's been done to them. But there are a couple of things you said that were so blasé as to be offensive. I think, like dwelling on mishaps, try saying that to a rape victim. I think, it's not fair. And you said, they're appealing to an authority to validate their pain, but do they not have the right to do so, given that the justice system in which we live has failed them and they have been raped? We don't live in a system where they can take justice into their own hand. We're no longer an eye for an eye. So that is what they expect from us, is that we allow that.
If my home was burgled, I'd want three things. I'd want the police to investigate properly, I'd want the CPS to prosecute effectively, and I'd want the courts to convict successfully. And in fact, every single one of us in this room would want no more and no less. My sense about victims' rights is that the reason why it's come centre stage is because each of those three objectives is not being met more and more. In other words, our institutions are in a sense of some crisis and are not able to deliver the services that we expect. Clearly, there are always going to be problems, but I do detect that there are far more problems now than there were some years ago. It's a real shame that Keir Starmer couldn't come to this debate this afternoon as he was originally going to do, because my sense here is that as a former director of public prosecutions, he has really felt the heat from victims. The reason why he's felt it is because those three objectives are not being met. And what troubles me about this debate is obviously there are many motivating factors behind it, but one of them is a sense of displacement activity, or at least a way these institutions protecting themselves from the heat and the criticism that they would otherwise experience. So, for example, it's as if where there's a prosecution which is not effective, then at least the victim is less likely to complain because they'll say, oh, I had a nice police liaison officer who came to visit me every week. And if there is ultimately a prosecution, albeit a successful prosecution after a bungled inquiry, then at least the victim will say, well, I'm not going to complain because I had my day in court, I had my say with the victim impact statement. And that's what really troubles me about this debate, because it does seem to me that it's being used as a means of covering up for a lot of institutional problems. And instead of addressing those problems, we're really accepting the fact that there will be no justice more and more often, but at least there will be victims who can say, I've been treated in a friendly way, so I'm not going to complain.
What I think is really striking is the difference between the way the public is seen in terms of public opinion that is supposedly putting the victim at the centre of things. So you say that Keir Starmer is, or the kind of pro-victim advocacy is driven by a sense of outrage among the public who want to see criminals pursued and punished. And yet at the same time, when the public is represented in the courtroom as a jury, it is a different kind of public there. It's a public that's critical, a public that it wants to see the evidence and is sceptical about many of the, many of the convictions that find their way into court, and particularly around the sexual offences, where the jury you're saying is actually very sceptical in terms of he said, she said, and weighing up, well, is there any corroborating evidence? Does it really stand up? And does it make sense that she waited 20 years to bring this complaint? And yet it seems that in public opinion, as it's represented in the media, that it's a very entirely different kind of a public. And it's an observation, possibly a question about these different conceptions of who we are and of ourselves as citizens in a democracy. Who are we? Are we the vindictive mob? Or the witch hunters, or are we questioning and critical people who are able to make decisions, very important decisions in courtrooms?
It is very caricatured, the idea of what a victim is today in terms of politics and policy. So the victim, I would say today, is understood as being fragile, damaged, and in need of support, which is a caricature, and it's a modern caricature. So it's something quite specific today. I have a master's student doing work on domestic violence, and I'm interested to know what you think about the way domestic violence is being policed today. In Scotland, Stephen House has become a Sir, I suspect, because of his domestic violence focus, and he's elevated this into what's called one of his 5 golden threads of policing. And if you talk to police officers involved in this, there are quite worrying stories about how one-dimensional they have to be in terms of their approach to domestic violence, which to me seems to be a form of policing of private relationships, which is going beyond what we've ever seen before. So I actually think the domestic violence stuff is possibly the most worrying trend in terms of policing. I'm interested to know, so that's a question. Another question is, do you think women are being infantilized in this process? So for example, in Scotland again, the police started a campaign where they would stand outside nightclubs. Oh no, it's not, they were going to train bouncers, that's right. Train bouncers, so that when women came out of nightclubs with a guy and they were drunk, they would walk up to the woman and say, are you sure you want to go home with this guy? Right. My third question is, what is rape? See, I was trying to work this out in terms of drink, because I think again in Scotland, the law is now, if a woman is very drunk and you have sex with her, you can possibly be done for rape. Now, I was trying to work this out, and I was thinking, I think my position would be, unless you're unconscious, it's not rape if the guy doesn't think he's raping you. And the reason I would argue that is that the same defense could be used by me getting absolutely pissed out my face, as drunk as that woman, get in a car, kill all your children, and say, well, I can't possibly be held responsible because I was really drunk.
Exactly who do you consider to be vulnerable? Because I'm sorry, but I think that everyone is vulnerable, and that you really shouldn't just categorize them based on their physical disability, their sexuality, or their gender. One of the reasons why I bring this up is because victims in general of sexual violence in UK law are identified as women and girls. And therefore that excludes that men and boys can be identified as victims. They are encompassed in that, but in print it is referenced as women and girls. As a result, over 85% of men and boys who are victims of sexual violence never come forward because they don't think of themselves as being recognized in the law. This, as a society, affects also the support that they receive, and the National Rape Helpline doesn't recognize them either. So if the law is representing them, why isn't it actually in print? One of the other big problems is that victims can be vulnerable, but those who are being prosecuted can also be everyone as well. Men, women, you name it. And I think that once we are blind to actually identifying and characterizing people, will be more easy to actually being able to utilize the law against them.
Anybody facing the criminal justice system has got a lot of disadvantages. As soon as a person is arrested, the police start interviewing the person before taking to station. And then when it goes to the station, reads to the other officer what this person has said, then only is the person having access to solicitor. Even that, the majority of people coming as claiming to be solicitors are not qualified solicitors and are providing a poor service for a lot of people who are facing very serious criminal charges. I work in the field of mental health. Yes, those days, it was very difficult for anyone with a mental health history to be taken seriously by the police because of the fear. They used to find out from the consultant, can this person stand rigorous questioning in court? Of course, it will be no. But now, they are doing it different. More and more people are able to get redress irrespective of their psychiatric history.
One of the things I haven't yet mentioned is what is being envisaged by the proposed changes to our system to improve things for victims. And what is being suggested is that there should be a lot more training of judges, and even the suggestion that before a trial even starts, the judge makes some kind of pre-prepared statement to the jury to say you shouldn't make assumptions about this particular type of crime or the sorts of people who experience it. And there is this sense in which the plan is to try and micromanage things. And I think that's very tendentious and again should be resisted because underlying it is this sense that I referred to earlier, which is that our institutions are just not working properly and they have to be somehow helped along. We haven't talked very much about the way in which victims are encouraged to think of themselves, but I do have a certain sympathy with the approach which says that it's actually more destructive and more counterproductive to keep giving people who have experienced crime the message that they are vulnerable, that they are traumatized, and that to go through a complaint and a prosecution is going to re-traumatize them, because I think that is denigrating the process, which is a serious process. It can mean that someone loses their liberty if the complaint is found to be proved in court. And I think that we need to perhaps return some of the dignity which this process involves to the process, and to make people more aware of the fact that it is society's civilised alternative to the blood feud, as John was suggesting, and to people taking the law into their own hands. And we must never forget that sometimes people do this with disastrous effects, like that Iranian man, Mr. Ibrahimi, who was wrongly accused of being a paedophile and was murdered in Bristol by a mob who were retaliating against him because he complained to the police about their behaviour. So nobody disputes that there are victims of extremely serious crime who deserve protection and vindication. But I don't think that constantly denigrating the justice system is the right way to go about improving things for them.
Sally?
I'm going to finish up just by picking up on one of the comments, I think it was John, that what actually appears to be going on here is covering up institutional problems. I have to say, I think I agree with you, because prosecuting as much as I do, I see the way that the CPS works. Just yesterday, I was at their offices and in two separate conversations that happened within probably 10-15 minutes of each other. I was told by a lawyer that she had 83 cases on the go. She was a specialised rape lawyer, so that's 83 separate cases that she was having to deal with, to focus on each of those individual allegations, to gather evidence, to give advice to police, to instruct counsel. It's slightly mind-boggling that one person should have that much to deal with. And then the other instance was a caseworker, someone who has to put the case together. He was extremely frustrated that he'd been given a very tight deadline to copy 1,000 pages of evidence and get it sent out to the defence within a very short, as I say, period of time. And I'm afraid it comes down to funding. The CPS are woefully underfunded. They don't have the staff levels to cover everything, and as a result of that, things are missed, and therefore complainants, witnesses, victims are not being given the level of service that they deserve. So on a different aspect of whether victims are being treated in the way they should, saying whether they should be entitled to speak up for themselves more, whether they should be looked after better in the courts, unless the case is prosecuted properly on their behalf, then we're never going to achieve that sense that justice is being done for everybody.
One thing which is quite interesting is the unintended consequences of some of these new provisions. And a good example of something which no doubt sounded like an extremely good idea in the planning discussion doesn't translate in a courtroom, and that is the provision of people's evidence by way of a video. So the idea is you make an allegation, you come to a police station, and nowadays, if it is a sexual allegation, irrespective of your age and irrespective of your robustness, and this feeds into the idea that we infantilise victims, you are put on a sofa, given a cup of tea, and there is a camera in the ceiling which will record your conversation with a police officer. That commonly takes around an hour, sometimes a little longer. Sometimes it can be, remarkably, very, very boring, which you wouldn't think possible in allegations of rape, but trust me, it can be. And it's then played to a jury. Now, if you then take advantage of the second set of special measures, which is the right to give evidence from a remote room in the building through a television link, what you actually get is a jury of 12 people who never see you. They never actually see what you look like. They can't judge relative sizes, for example, between you and the defendant. They can't get a read on any emotion that you might be expressing in your interview, because a camera unquestionably dulls that emotion. And for my money, when I defend, I am absolutely delighted if a victim wants to be in the remote room, because I know it will work to my client's advantage. When I prosecute, the first thing I do is go and see the victim or the complainant and say, please come into the courtroom behind a screen so the jury can see what you really look like. And it makes a huge difference, and that is an example of something which is supposed to help victims that actually in many, many cases has the opposite effect. So I think people perhaps ought to think about the practical consequences of many of these legislative changes before imposing them on the system.
Great, thank you, Sam. And John.
One thing that hasn't actually been mentioned, but it is in the blurb and everything, it's the word therapeutic. And I don't necessarily sneer at therapeutic or at therapy. Maybe the more it's dissociated from its medical roots, the better. But the idea of healing or making people feel better, you know, having that effect, I think is a desirable thing. That's why, for example, I thought that what are called victim personal statements in this jurisdiction, that the VPS is not necessarily a bad thing, you know, to give the victim at the end of a trial that is now a victim to make comments about the effect it's had upon them. That seems to me to be relevant, actually, to the harm done. And when a judge is sentencing, a judge takes everything into account, takes all those matters into account, and that's one of them. And there's no reason why the judge shouldn't be informed in that respect, in a controlled way. There was a disturbing example of a judge leaving the bench crying, having read the victim personal statement. That's not very encouraging, but the judge did go away and compose himself in that case. I'm glad he did, and that's what the judge's job is. They're professionals and their expertise, and they have an expertise in that regard. I do want to comment about mishap. Thank you for picking me up about that. It was an umbrella term. I mean, I wouldn't refer to a particular rape or murder as a mishap, you know, one-to-one, of course not. But I'm trying to, you know, I was trying at the time to take it all together. I mean, I'm in legal practice, you know, we deal with victims all the time, i.e. people who've been tortured and, you know, very, very badly treated indeed, asylum seekers that you see. It's not a matter of a lack of sympathy for them, it's out of sympathy for them that, you know, somebody ought to tell them things can get better. Everybody always says, this will be with you forever. I never hear somebody saying, this person will not be scarred for life, let's hope they get over that soon. I hope they do.
Great, thank you, John. Can we thank our panel?